Good afternoon, and welcome to the Appellate Division First Department. You might be wondering, why am I sitting in the center seat here? Because the presiding justice on the bench today is Justice Acosta. But as you can see, he needs to be joining us on the screen today. So he's still the center person. He's obviously still the presiding justice and the justice presiding. But somebody had to call the calendar and work the lights, so that's me today. So just to explain the semantics of how we have to change things a little bit in the world we're living in. So both Justice Acosta and Justice Higgett are on the screen. I think you can see them. And they will be able to hear us. Hello, my colleagues. And we'll now call out the calendar. The first case on the calendar this afternoon is People versus Khalid King. Appellant, how much time would you like? Okay, and the respondent? Fine. 5 and 1 and 5. Goshen Mortgage versus Crawford? Okay, that case is submitted. R. Laura versus Thomas B? Is there a respondent? Okay, you would still like to argue? Okay, we'll give you 5 minutes, and we have additional questions. We'll continue on. Thank you very much. People versus Jason Rivera.
Yes, I would request 5 minutes.
Okay, and is there a respondent?
Yes, our respondent requests 5 minutes.
Okay, 5, 1, and 5. Saint Germain versus Seaman.
Appellant 7 plus 2.
How many? 3? And there's one. And you represent whom? HSBC, okay. So Saint Germain will give you 6 minutes and 2 in reply, and then each of the respondents will give you the time you asked for, 3, 3, and 2. Okay, thank you all. People versus Count C.
Appellant requests 3 minutes on direct and 1 in rebuttal.
How many? 3. Okay, 3, 1, and 3. Tudor Perini Corp. versus New York City Department of Transportation.
Appellant requests 8 minutes and 2 in reply. Respondent 5, Your Honor.
Okay, we'll give you 6 and 2 and 5. Thank you. People versus Omar Ahmed.
Appellant requests 2 minutes, Your Honor.
Is the okay, 2 minutes for each side. Thank you. Beckman Coulter has been is being adjourned officially at the calendar call, so that case is adjourned. Acevedo versus Nurmagomedov. Sorry if I got that wrong, but that case is submitted. And then the ALP versus Moskowitz and Max versus ALP. You're appellant who, on which case? So you want to, do you want to argue these together? So how much time do you want? Okay, and?
Your Honor, respondent wants 5.
Okay, 6 and 2 for the appellant and 5 for the respondent. That's for both cases. Okay, thank you very much. The first case for oral argument is People versus Khalid King. Good afternoon.
Good afternoon, Your Honors. Elizabeth Caldwell from the Center for Appellate Litigation on behalf of Mr. Khalid King. May it please the Court. I plan to address the Molyneux argument today. The Court erred by admitting Molyneux evidence without a sufficient evidentiary basis and without a proper legal basis. First, as a threshold matter, the prosecution failed to show that there was clear and convincing evidence, or even a lower standard of proof, that these incidents had ever occurred. The Court of Appeals in Robinson several decades ago established that clear and convincing evidence is required before the prosecution can offer Molyneux evidence to establish identity. The court should clarify here that the same standard applies to all Molyneux evidence, regardless of the purpose for which it's offered. And there are several reasons that the court should adopt this rule. As the Court of Appeals recognized in Robinson—
Ms. Caldwell, why do you think that the court did not do the proper balancing in this case, particularly, to try to get some context for the relationship that existed of violence and, however we want to characterize the relationship the jury was entitled to know?
Your Honor, I disagree that the jury was entitled to know about this. The Court of Appeals has made clear that anytime there's some background of abuse that's alleged, that doesn't automatically mean that prior bad acts are admissible. And the Court of Appeals made this clear in People v. Leonard, where there was similarly prior abuse between the same parties, and the Court of Appeals said, no, this is not necessary background information. And we have the same thing here. This is not a case where we have interwoven events that are only understood when you hear the back and forth of prior bad acts. This is a case where the prior acts that were admitted were years removed, and they had the effect of essentially refuting the defense only on a propensity theory. So that's why—
But as the court, in People versus Dorm, though, the Molyneux or past behavior was or evidence to explain the relationship was allowed to place the behavior of both sides, of both parties, in context, in what the court characterized as believable context, right?
Your Honor, this case is distinguishable from the facts in Dorm. In Dorm, there was actually a series of back and forth incidents in a matter of weeks that the complainant had reported to the police. Then the defendant came to her business. And I think that the action that she said was so fearful in that case was the fact that he had touched her hand, actions that otherwise would seem totally innocuous to someone. So this is a case where the facts speak for themselves. The allegations were that Mr. King had threatened her with a knife. So this is not something where we need additional information to be able to understand why this was threatening to her, why she called the police at that point, and why she was understandably fearful. This is really a different set of facts, and these incidents that predate this incident by a matter of years really don't help the jury understand what was going on. And I think one thing it's telling is, the complainant called the police. She tells the police what happened on the night of the incident. She tells them about an argument they're having and how it escalates that night. And it made perfect sense. It wasn't a case where you needed these prior bad acts to help explain what was going on. And at the end of the day, the way that it was used, and it was used by the prosecution in summation, was to characterize this as kind of the culmination of an abusive relationship where she finally calls the police. And that's precisely what the Molyneux rule bars. So for that reason, this was not appropriate. First, as a legal matter, there was no reasonable basis to introduce this evidence. And then on top of that, this wasn't a proper balancing because first we have an insufficient evidentiary foundation about these prior acts.
Initially, the people had sought to introduce 8 separate incidents. Is that correct? And the judge, in trying to, in balancing it, suggested that 2 of the incidents were the most appropriate to put in.
That's correct. The judge did exclude a number of things, but that doesn't mean that this court doesn't have to decide as a matter of law whether there was a proper non-propensity basis for admitting this evidence. And we submit that that was not present here. There was no proper non-propensity basis to admit this evidence. And so we don't even get to the balancing test if there's not that proper basis. And even on the balancing, again, the fact that, this goes beyond a lack of corroboration. She had actually contradicted her own statements about prior abuse. She twice denied that there was prior abuse. And for that reason, we ask the court to vacate Mr. King's conviction and remand for a new trial. Thank you, Your Honors.
Okay, you'll have a moment in rebuttal. Thank you very much.
Good afternoon, and may it please the court. Jillian Lewis for the people. The trial court here did not allow the people to introduce 6 incidents.
No, as you heard, I indicated we're aware of that, but how did these 2 specific incidents really help fill out the picture or give a context that we wouldn't otherwise have had from the testimony that came in as to what happened in this particular case?
So these 2 incidents in particular helped to explain the relationship between the defendant and his wife, the victim here, as well as the behavior of the defendant and the victim preceding and at the time of the incident. Now, these 2 incidents that were introduced were heavily sanitized for the jury. For instance, the second incident, the jury only heard that an incident of violence occurred, and because of that, defendant had moved out. The court was very careful and measured in their decision when looking at the people's full Molyneux application, and they excluded things that would be prejudicial. They excluded the fact that during that allegation of the May 2017 incident, defendant was alleged to have restricted Alicia's breathing, a charge that was being brought in this very case. So with that limiting and sanitizing information, here the court really just drew out information to explain the relationship, which oftentimes in domestic violence cases needs to be contextualized. The actions of the victim here were further explained.
Why couldn't that intent and motive and the relationship be explained, one, as defendant argues, from the charges that were made and from other evidence in the record?
So without this information, the jury wouldn't have a complete understanding of the relationship with the defendant and the victim. Here, they would be under the impression that that relationship was violence-free before this December 2018 incident, which was not the case.
But why was that necessary to supplement the the charges in this case and the testimony that they heard? I mean, why really was that necessary? I'm having a hard time figuring that out.
So it was necessary to explain the actions, to explain why after this incident, Alicia, the victim here, immediately called the police and called them despite not having visible injuries. The fact that she didn't engage with him when he first came to the apartment.
If the justification that you're offering today for admitting this evidence, it would mean that in every domestic violence prosecution, you would be permitted to get into the history of what's gone on before. I mean, the crimes that are charged here are rather straightforward. The defendant is charged with having put a knife to his wife's neck. You know, why is the history particularly relevant to establishing that charge?
As this court has held in People versus Dorm, it can be necessary to paint testimony that may otherwise be unbelievable in a believable context. Additionally, this incident is much different than People versus Leonard, where the exact same offense that was alleged was introduced at a prior act. So here we're just merely showing and explaining the relationship between the defendant and his wife and putting it in that believable context.
Excuse me, counsel, I'm sorry to interrupt you. I just wanted to know, was the victim's credibility or believability or that of the child's, was their credibility or believability challenged by defense counsel either in openings or summation?
Yes, it was challenged throughout. It was challenged in openings and summations and through cross-examination. So it served as well as a way to rebut any doubt that was cast on the testimony of both the victim and her son, who were there to witness this incident. Additionally, any error regarding the admission of the Molyneux evidence would have been harmless here. If I may just briefly conclude.
I'll give you 30 seconds, sure.
Despite hearing evidence of these two prior instances, the jury also heard numerous facts and testimony from their son, from the victim, as well as saw text messages, phone call logs, all of which led to them concluding that defendant was guilty of this charged crime. Additionally, the jury was not overwhelmed by this evidence and actually did acquit defendant of one of the charges before him, which was obstruction of breathing. So it did not unduly prejudice defendant to introduce those two pieces of Molyneux evidence. Thank you. We ask that you affirm.
Thank you.
I'd like you to pick up on a point just made by your adversary. If there was error in this regard, why wouldn't it be harmless?
Yes, Your Honor. This would not be harmless error, and I think, first, the evidence here was not overwhelming. This comes down to a credibility determination, and we know from the split verdict that there were concerns about the complainant's credibility. The jury would have had some concerns about her testimony when it rejected the second count. On top of that, that means that the case really came down to the believability of a 12-year-old child who was autistic. He had recently learned that Mr. King was not his biological father, which he had lived his whole life thinking. And so he had reasons to perhaps exaggerate what had happened as well. On top of that, so this really comes down to credibility, and so I don't think you can characterize this as overwhelming evidence. On top of that, even if there was overwhelming evidence here,
I mean, when you say it comes down to credibility, I understand there are issues about aspects of the testimony, but what actually creates doubt about this verdict in terms of the credibility? I mean, is it your position is that this was just a made-up tale by Alicia?
I mean, yes, Your Honor, there was clearly some dispute and argument going on between them about these visitation rights, but that it amounted to this sort of violent incident. It all came down to whether the jury believed her or not. And here we have a jury that did return a split verdict, which suggests it had concerns about her credibility. So I don't think this can be a harmless error when that's the nature of the evidence, and you have the prosecution arguing in summation that this was a series of incidents over the course of years that culminated in this violent incident. That has to be at least a reasonable possibility that there was that this evidence would have tipped the jury in favor of the complainant, and the limiting instructions really insufficient. And the Court of Appeals has recognized, and with this kind of evidence in particular, limiting instructions are only so valuable. So for all those reasons, again, we ask the court to vacate Mr. King's conviction and remand for a new trial. Thank you, Your Honors.
Okay, thank you both. Next case for argument, are Laura, just the appellant, is here? Yes. Oh, sorry.
Good afternoon.
Good
May it please the
afternoon.
court, Mary Ellen Liberatore on behalf of the appellant mother. The support magistrate erred in finding that the respondent father met his burden of providing competent, credible evidence of his inability to make the required child support payments in order to rebut the presumption of willfulness as required by the Court of Appeals holding in Powers v. Powers. Specifically, the support magistrate committed reversible error when he refused to allow evidence into the hearing with respect to the father's long history of receiving significant financial support from his parents, mainly.
Well, let's look at the rebutting evidence, Ms. Liberatore. He was able to present, according to the magistrate, credible evidence of his inability to pay support. He showed that the children had lived with him full-time since February of 2020 without the mother's objection. He gets unemployment compensation. and his child care duties hamper his ability to work full time.
Yes, Your Honor, there was no support in the record for those findings. The father did not have custody of all three children
Well, but
until...
all three children were living with him, weren't they, once the pandemic came and he was supervising their daily virtual school, which with three boys, I'm sure was not an easy job. And he was doing that and taking them to activities, and they all had individual education programs. So why was that not pretty much a full-time job?
Well, because first of all, that ignores the fact that he stopped paying child support 9 months earlier. So at the conclusion of the hearing, he had not paid child support for 21 months. It's now 3 years. At the time, it was 21 months. 9 of those months...
Paolo was living with him at that time, right?
Paolo began living with him, yes, in 2018, but unfortunately, the support magistrate did not allow the mother to testify as to how that came about and the efforts that she made to repair her relationship with her oldest son. And so it should not be used against her because he would not allow her to respond to that.
But is it a matter of being used against her? It's a matter that these are the facts, that he was living with the father at that time.
That's correct. That's one child. The support magistrate said that having custody of 3 children was a defense, and that didn't happen until March. The support magistrate's holding also fails to consider the role the father played in creating a situation by not paying child support, that the mother had nowhere to live with the children. She had no choice but to give the children to him. So during COVID, because she couldn't afford a home of her own without the child support. Had he paid the child support, she wouldn't have temporarily relinquished custody, and this defense would not exist. The truth of the matter is that the children being homeschooled and him having to supervise them was just an excuse. The father did not work. He did not look for work because he has always been supported by his parents.
How could it have been an excuse? He had full custody. Well, he had physical custody before the pandemic, and then after, and really was shuttling the kids from his home in New Jersey to New York City, and then supervised them once the pandemic started. So
Because the support that was,
I thought from reading your brief that you were not challenging the findings, and you were simply arguing that they should have been a finding of willfulness on his part, and you wanted the father incarcerated for 6 months. Did I misread your brief?
No, you're right. I'm asking that there should be a finding of willfulness because the support that was ordered in the judgment of divorce was never based on the father's actual income. It was based on his imputed income, the income that he received from his parents. That in the Pendente Elite order, Justice Strager imputed $175,000 to the father from gifts he received from his parents. The child support that was ordered in the Pendente Elite order is the same amount of child support that the parties agreed to in the stipulation of settlement and which was incorporated in the judgment of divorce. The father testified extensively that he is still supported by his parents. They pay for his home, they pay for his car, he doesn't contribute to utilities, they pay for his clothes, they pay for his food, they give him cash, a credit card. He still receives all of this support. So the fact that he couldn't work is just an excuse. The support ordered was never based on his actual earnings. It was always based on his imputed earnings, and it was reversible error for the support magistrate not to allow that into evidence.
Can I ask you something about the counsel fees? That was one of the issues that you also challenged, one of the objections that you made to the support magistrate's findings. So you did not put in, according to the record, the full agreement because you left out the one of the documents that was attached to it. Could you talk about the counsel fees? Did you show what was paid, what your client was paying you?
Yes, Your Honor. So the support magistrate excluded the retainer agreement from evidence because there was not a statement of client rights and responsibilities attached, but that was done that was an error. The statement of client rights and responsibilities had nothing to do, and it wasn't necessary for,
Why didn't you offer it again with the statement attached?
because the support magistrate said he didn't need it, that she could just testify to the financial arrangement between her and her counsel, which she did. And she also admitted into evidence very detailed invoices that set forth the work that her attorney did and the disbursement. So under the case law, there was sufficient documentation to allow the court to award counsel fees under the default provisions of the stipulation of
Was there any
settlement.
evidence introduced as to funds that were actually paid, invoices, or that payments were actually made?
She testified that she had not made payments, but that it was just the
But you had given her invoices.
invoices, correct, that set forth the amount expended.
Anybody have any further questions?
Good.
Okay, thank you very much.
Thank you so
for
much.
coming in. Yes, have a nice afternoon.
Thank you.
The next case for our argument is People versus Rivera. Good afternoon.
Yes, good afternoon. Good afternoon, you may please the court, John Vang for Jason Rivera. I'd like to direct the court's attention to the missing witness point. In Smith, the Court of Appeals reaffirmed the Gonzalez burden shifting framework for analyzing missing witness instructions. It made clear that the initial burden of cumulativeness never rests on the moving party.
The People versus Smith case, which is a Court of Appeals case, came
Yes.
out after the trial of this case,
It
correct?
did come out after the trial, but I think the Gonzalez burden shifting framework was very clear. And I think what Smith did was it said, Gonzalez was very clear about where the burden rested. Who had the burden of proving cumulativeness here? The burden always rests on the opposing party. The defense here did actually make his prima facie showing. He showed that the missing witness would have given material testimony and would have been favorable to the prosecution. At that point, the burden then shifted to the prosecution to prove cumulativeness, but instead of doing so, the prosecution bumped that burden back on to the defense.
But given that video,
Yeah.
what really would this particular, he was the gentleman that took the video, is that correct?
Yes, that was the missing witness, yeah.
What suggests that he would have given any testimony that was not cumulative?
Well, there are events that happened before the video, all right? There were exchanges outside of the bodega that the video didn't capture. Those were the exchanges that were central to the justification defense. The video doesn't show the bigote, which is the decedent, who was the initial aggressor here, coming at Mr. Rivera and his son with a metal
What's
pipe.
your basis of saying that Koba knew something about that?
Well, he was there on the scene, and I think the only showing that's required by the Court of Appeals is that he was there on the scene. He was there certainly before. Angel Santiago suggests that certainly he was there before Angel Santiago even appeared on the scene. So he was there, present on the scene to witness the events outside. Something obviously triggered him to pull out his cell phone.
He wasn't there to witness the event. You're assuming that he was. Obviously, he was there, but you're assuming that he witnessed something that isn't captured on the video.
Well, Your Honor, this is the point. The point is that the video doesn't capture the entire thing, but something obviously happened. He was obviously there in the scene. He witnessed something. Something obviously happened before to have him decide to pull out his cell phone and start recording. And
Yeah, but isn't the point, counsel, isn't the point that the defendant had already disarmed Bigote and the guy was lying at the end? Your client could have easily retreated without any consequence, correct?
well, the justification defense didn't only apply to Mr. Rivera. It applied to his defense of others as well. That's how the court actually charged the jury.
How can Bigote have harmed anybody face down, unconscious, on the ground, and getting 2 additional hits with a pipe?
Well, I think that's...
that video is overwhelming.
I don't think that that video is overwhelming, Your Honor, because again, there are events that happened outside of the bodega before the missing witness even started recording. And, you know, there's no dispute here that, again, he was the initial regressor. Mr. Rivera was not only
Well,
entitled to
let's
defend
assume,
himself.
I grant you, let's assume that Bigote was an 80-year-old man, 80 years old,
Well,
was the initial aggressor. Let's assume that that's the case. At what point could your client have retreated? I mean, once he hit him the first time, the second time with the pipe, when when Bigote is face down, immobile, on the sidewalk.
well,
I mean, your client could have retreated with his son at any time after the initial hit when Bigote was face down in the concrete.
well, I think that's part of the problem with, well, first of all, you know, part of the problem with not having the missing witness instruction is that, again, we don't see what happened before the video. And the defense wasn't able to argue to the jury that the fact that the prosecution didn't bring in this missing witness who was there on the scene, who also witnessed the events, who then decided to pull out his cell phone and start recording, that he would have given testimony that was unfavorable to the prosecution and that would have favored the defense. What the defense had testified to, the son testified to, was that Bigote was going to also attack the son. And, you know, my adversary argues, you know, certainly that he wasn't able, he should have retreated for himself. But again, he was entitled to defend his son as well. This is a parent who was running towards
No,
danger.
I agree with you. I agree. He was entitled to defend his son. The underlying question that I haven't heard you answer is whether Bigote posed a threat at all after Mr. Rivera hit him a couple of times with a pipe.
Well,
The guy was just immobile, face down on the sidewalk, and still got another couple of shots in the head.
I think the analogy is if someone shoots and then is firing additional shots after. I mean, I think the point is that there's a huge series of events that occurred before the video even captures anything, and it's unfair to the defense. The defense wasn't able to argue to the jury that the fact that the people didn't bring in the very person who was also on the scene, who witnessed, you know, the essential events that were critical to the justification defense, the fact that they didn't bring him in says something about their case and that it supported the defense case as well. Thank you.
Okay, thank you. Good afternoon.
Good afternoon, Your Honors, and may it please the court. My name is Shane Magnetti, and I represent the Bronx District Attorney's Office. I want to start with the cell phone video. As Justice Acosta pointed out, in the video, you can see Bigote lying face down, motionless on the sidewalk. Defendant is standing over him, clutching a metal pipe, and he can be heard screaming, and I quote, "Give me the effing money." He then proceeds to bludgeon Bigote with the pipe over and over again. His son even tried to grab him by the arm in the video as if to pull him away from Bigote, but defendant continued the attack. These are not the words or actions of a man who is acting in self-defense.
But what was wrong with the argument that you should have brought in Kova as a witness who was needed to authenticate that video? Because clearly the defendant, I mean, I hear counsel talking about what preceded, you know, the beating, whatever you want to call it, of Bigote. I mean, there had to be a context for that, and I you know, what would have been the harm of bringing that witness and avoiding a missing witness charge? And if you didn't bring him, then allowing a missing witness charge. I mean, the evidence was clearly not cumulative. I don't believe that.
Okay, well, Your Honor, regardless of whether the evidence is cumulative, and I'll get to that, but I just want to address a few points first. I want to direct the court's attention to what the offer of proof actually was when defense counsel asked for a missing witness charge. And it happened at pages 298 to 299 of the record. And the court asked, why should I issue a missing witness charge other than the fact that this witness is not here? Counsel replied verbatim, these are witnesses known to the people that have not been brought before the court. He never addressed materiality. It was a bare-boned request that was plainly not sufficient to satisfy his prima facie burden. Regarding whether the testimony would have been cumulative, the court aptly decided that it would have been because, as the people argued, it merely reflected Koba's perception of the video, and he only would have narrated what he had
The,
seen.
the initial argument by defendant's counsel was that Koba, the witness who took the video, was needed to authenticate the video itself, right?
Yes, that's what the majority of counsel's arguments were regarding Koba, were to the authentication of the video.
Yeah, he only got into the clearly cumulative argument later on. But he said, you need somebody to authenticate the video. It's not self-authenticating. There was a context before that.
He did. He made an authentication argument, Your Honor, and the people authenticated the video through Angel Santiago, and authentication, my adversary does not contest on this appeal. And I just also want to point out that the argument that Angel Koba could have seen events that happened before he began filming is based on one line of Santiago's testimony.
Well, wouldn't it make sense that, he took out a phone to film something, so he must have seen something that made him take it out to do that. So he must have seen something before. That was why he took out the video, took out the phone, even assuming he was holding it, and started filming it. So something must have, happened before.
That's correct. There would have presumably been some triggering event that caused Koba to take his phone out, but there's no reason to believe that that triggering event was this initial exchange that my adversary refers to that Jason Jr. testified about. The idea that Koba is there for the whole time, when Santiago testifies that he was there filming the whole thing, well, we've seen the video. He plainly was not filming the whole thing, and to assume that he saw this initial exchange, Santiago can't testify what Koba saw and what his perception was. And regardless of what he did see, regardless of Santiago's testimony or Koba's, the uncontested testimony from Almatari and the cell phone video established that this defendant continued to bludgeon Bogote over and over again while he lay helpless on the floor and could not even get up. That is not justification regardless of what Koba would have testified to. So for that reason, any error would have been harmless. The evidence of his guilt was overwhelming, and we would ask that this court affirm.
Okay.
Thank you.
Thank you.
As for whether the defense had actually made out its prima facie burden, the people below never disputed that the defense had established materiality or favorability. The only thing that people disputed below was that it was the defense's burden to prove cumulativeness, which under the burden shifting framework, it's clearly not the defense's burden. And because the court endorsed that analysis, that was error as a matter of law. But with respect to the harm issue, with respect to what Koba could have seen, Santiago actually said that Koba was there. And the fact that he was there at the crime scene, he was there witnessing the entire time, that's sufficient to establish, what the defense needs to show in order to get the missing witness instruction. And finally, there was reference to what Almater saw. Almater didn't witness any of the events. By the time he came out, the decedent was already on the ground. But I think it's important to emphasize with respect to harm that, the issue in this case was whether or not the defense had established or whether the people had disproven justification. That was the issue. And the events that occurred before the bludgeoning, fine, maybe he may have gone beyond what he should have, but the initial conduct, that's the conduct that's relevant to justification. That's the conduct that the court has to examine and see whether, and for the jury to examine to determine whether or not he was actually justified. And he was justified to defend his son. There was a dispute between the defense and prosecution witnesses about whether or not the decedent was actually going to strike the young child. And the defense's position had always been that that was why the defendant had actually gotten up to defend his son.
Counsel, do you wanna address the sentence? He got 25. The people asked for 25. He got 3 above the minimum of 15. So you want to address that?
Again, as we argued, this is someone with a very minimal criminal record. He's someone who has, been very much a father to both of his children. There's
I mean,
mitigation
he had
here.
no previous felonies. He
He had no
had
previous
barely any
felonies.
criminal record.
None
Was a
of
father, had
He was a
worked.
father, exactly. He was, this is clearly an aberration, from his history. There is mitigation to the extent that the court doesn't find that was relevant to harm. Certainly, the fact that he was defending his son is mitigating under the circumstances. So, for these reasons, we would ask that the court, in the alternative, reduce the sentence. Thank you.
Okay, thank you. Saint Germain versus Seaman?
May it please the court, Tim O'Shaughnessy from the MTA. First, a piece of housekeeping.
Yes.
After I filed the brief and record, the plaintiff called me up and said, your record is missing a photograph. And I said, you're right. I prepared a supplemental record and a stipulation. I sent the stipulation around, asked people to get back to me. And I think everyone had gotten back to me except one person, and I just forgot about it. Okay, my fault. The other day, the plaintiff contacted me and said, it looks like this supplemental record never got filed. So on Monday, I filed the stipulation and the supplemental record. On Tuesday, I got an email saying from the court saying they were accepted, and I should file 2 hard copies of the supplemental record. And this morning, I got an email from the court saying, we are rejecting these documents because they're late, because the case has already been calendared for argument. So I request the court to reconsider that decision by the clerk. I'm sure that I'm joined by all of the other parties.
What else is in that supplemental record other than the, a photo, you said?
There's one photograph, Your Honor.
That's all it is one photograph?
That's all it is.
Yeah.
He's the boss, so.
Yeah, we'll take it. I don't. Yeah.
Okay.
I'm more concerned with the 1953 lease, to be honest with you.
Okay. So the plaintiff has 5 copies she'll hand up.
Okay.
I mean, I don't understand why you didn't stipulate. Generally, you sign the stipulation, you submit it to the court, and that's the end of it. So I don't understand why, even now, there isn't a stipulation with all agreeing that I mean, it's a photograph.
Yes, right.
Yeah.
Okay.
This
Okay, go ahead.
defect, plaintiff made a little X on the photograph. It's clearly on the sidewalk. It is not on the stairway. It's not on a landing. So because it's on the sidewalk in the city of New York, it's the responsibility of the adjoining landowner to maintain and clear snow from that spot because it's a commercial building.
Well, I have another photograph that was in the regular record that I saw on page 783 of the record. Yours is at a different angle, but, there was this lamppost that was right there, and I think that figures into it, the story a lot, and you really couldn't, it was really be very difficult to walk around there. I mean, honestly, this picture seems to have stuff in it that was not in this other picture, maybe.
Well, I think that would be a special use argument, Your Honor, and the fact that we cited a number of cases that sidewalks near a special use are not the responsibility of the person who is responsible for the special use. There's no question here that she just slipped on snow and ice right on the sidewalk.
Didn't your...
Well, in an area primarily used for egress and ingress into the subway. No?
It was about 1.5 feet from the stairway. So that's the Bingham analysis, whether that was a passageway primarily used for access to the subway. And in fact,
Didn't someone from the Transit Authority or MTA testify that they would generally clean and shovel the area approximately 3 feet from the beginning of that stairway entrance to
yeah,
the?
that's a different argument that my colleagues make. That's an assumption of duty argument. There's no statute or regulations saying that transit has to do that. And so when
No,
there's
but the 1953 lease requires that you are responsible, or states that you're responsible for maintaining areas incidental to or necessary for the operation of a subway station. That area is like within a foot of the entrance to the subway station. It's clearly within that language. You disagree?
I disagree, Your Honor. It's a public sidewalk. If in the city of New York, the legislature or the city council has determined that the public sidewalk, it's either the city or the adjoining landowner who's going to be responsible for the public sidewalk. And if we're going to use that language, or if we're going to use the Bingham language about primarily used, it's impossible to determine the boundaries of that duty. Here we have a defect 1.5 feet away from the stairway. But people come walking toward that stairway from blocks away. They come walking up 6th Avenue. They come across 14th Street. And all of that area could be called something primarily or ordinarily used as access to the subway.
So why isn't that then characterized as leased property pursuant to the 1953 lease, for which you are responsible?
That's
I mean, that's
because it's
I know that you think that 7210 of the administrative code trumps that lease, is what you're saying?
Yes, because it's a sidewalk. The city owned the subway system, and this really wasn't litigated below. The city owned the subway system, and when the subways and buses were leased, I think areas incidental mean like staging areas and parking lots for facilities where transit people work. Plaintiffs really didn't argue that, or none of the parties argued this, made that point below. And what I was trying to say about assumption of duty is that when a plaintiff sues for breach of a duty that's been assumed, the plaintiff has to show justifiable reliance, which is not pled here, which the record doesn't support. The other sort of assumption of the duty notion here would be that if you, whether you have duty or not, if you shovel some snow and you make the condition worse, you create a dangerous condition, you can be liable in negligence, but that was not pled here, and the record would not support such a finding. The plaintiff testified that when she got there, there were no footprints in the snow had not been shoveled or plowed, and there was no salt or stand around.
Did your own employee acknowledge that it was your policy to clear the area where plaintiff fell of snow and ice?
It is Transit's policy to have its cleaners remove snow and ice for up to 3 feet.
And why do you do that? Because it's not your obligation? Or you do it because it is an area consistent with the area for which you're responsible pursuant to the 1953 lease?
We do that as volunteers so people don't slip and fall when they're approaching our subway station. We have no legal obligation to do that, and plaintiffs, the other parties haven't cited a case or statute or regulation.
And you say that because this is not an area that's incidental to or necessary for the operation of the subway. So you're not required to pass by that area to enter the subway station. That's what you're saying?
We could operate the subways without that.
You're not
there.
Well, with fewer passengers, if they're not able to get in, right?
Well, they'd have to use another entrance, but see, I mean, we're having a kind of a very hypothetical situation. I think that areas incidental means, it doesn't mean the public sidewalks or the public streets. For example, this covers the bus the bus companies. It doesn't mean that the city leased us the streets that the buses run on.
Judge
It's
Friedman?
incidental or necessary. So, but okay.
You're saying you're not responsible for the top step either?
No, we'd be responsible, we're responsible for the stairway, absolutely, but that's not where she fell.
Okay, who wants to argue first? Plaintiff? That's fine, sure. You have 3 minutes, okay?
Thank you, Your Honors, and thank you for accepting the supplemental record. I believe the photograph is pretty dispositive to the case.
Okay,
Um,
problem.
So yes, this is a leased property under McGuire, is incidental under Haberlin, but I think what's really critical here under assumed duty is Stephen's testimony that she doesn't just clean this area of snow and ice 6 times during her shift, she actually cleans the area that she made the box in SR1, which has an X. She cleans it 3 to 4 times during her shift, even when it's not snowing. So this, I don't know how, I mean, you're shaking your head. I should probably just sit down. This is just, there's no other way to look at this evidence that she doesn't, of course they're responsible for this. The whole reason why she spends 3 to 4 times on her shift when it's not snowing and 6 times during her shift when it is snowing, cleaning this area.
He said she was just a volunteer, counsel for the transit. That they were just volunteering there.
I don't know how she could be a volunteer. If you look at 1976 of the record, it's a log of the employees that are working in their shifts. She's been, working for I don't know how many months or years at the station.
No, I don't think that she's a volunteer, that they were volunteering their services to do something that they were not obligated to do.
Well, I think by the fact that they are, well, there's no evidence that she's a volunteer, but they're responsible for cleaning the sidewalk. So they have an assumed duty, and if they undertake it and they're negligent, then they're responsible. I think that the log shows that even at 7:50 at night, the night before, there was snow duty. We don't know what was done. And in addition,
This happened at like 4:40 in the morning, something like that?
Yeah, so 16-123 is applicable. We understand there's nothing that they have to do until 11 in the morning. But here's how this works with that, as you know. I don't have to tell you. So if you're saying storm in progress, and if you're saying 16-123, the defendant is the movant, still has to establish that she slipped and fell on current, fresh precipitation from the storm that actually ended the night before, so it wasn't in progress, and not from a prior snowfall. And here, the evidence is pretty compelling that you have her testify at 3:03 of the record that if Friday morning was 3 days before this incident was the last time she had traversed this area, she saw snow piles in that area. That's at 3:03 of the record. In addition, you have weather records that show the tempers fluctuating in the week before, and then there was 11 inches of snow on the ground. This is at 2:01, 2:31 of the record, and 2:48 of the record, that there had been precipitation a week before in February, and the week before February 22nd, and that there also was temperatures as high as 38 and as low as 4. They submit meteorological records with no expert to interpret them. It's their burden to establish that this was the result of the current precipitation and not anything prior. And to that end, the plaintiff testified pretty specifically that she slipped and fell, and underneath this fresh snow was hard, thick ice. So it's our position on this appeal that the trial court got it right, and we ask you to affirm.
Thank
No
you.
other questions? I'll rest on my brief. Thank you.
Okay, thank you. You represent the Seaman or Colin? Yes. What do you call them? Seaman, is that what
I'll
you?
call them the Collin defendants. I
Okay.
think that's how we referred to them in the briefing.
Yes, right, that's correct.
So essentially, they're the owners of the building on that corner, which
Right.
was an HSBC.
Which you were leasing out to HSBC.
Yes.
Who's going to talk
Yes,
next.
Your Honor. So this is a weird, I've never been in this position where I am actually agreeing with plaintiff's counsel on the argument here. And it's kind of strange because I think what transit is saying is they're out and I'm back in. But the plaintiff did not appeal the order as against me. So if the court is reinstating a common law indemnity or a contribution claim, it just doesn't quite make sense because transit's either in or out. It's us or them. And I will just address this concept of, is it a landing? Is it a sidewalk? I think common sense, just looking at that photo, this is a landing to that staircase. I think that the Echeverria case, where this court found that the transit authority could be negligent, could be found negligent. This court affirmed a jury verdict for negligent maintenance of an exterior landing to a subway entrance. That's what this case is. I don't care what you call it. We're not talking about the sidewalk to the right of the entrance. We're talking about a foot, which transit admits in their brief, in front of that staircase. We're not talking.
It's incidental or necessary to egress and
Absolutely, Your
ingress
Honor.
of the subway.
Absolutely. This was the only way to get to that. You had to go in that direction to get onto that staircase. We're not talking about jumping over a curb or the sidewalk down the street. We are talking directly in front of a staircase. So if there aren't any other questions, I can.
Is it your view, as it was the plaintiff's view, that based upon Zare Stevens' evidence, the station cleaner, that this was an area which had usually been cleaned by the transit authority?
Yes, Your Honor, and I believe that is because of the 1953 lease. They clean it because they are responsible for ingress and egress. They don't want their patrons, subway, people going down to the subway to slip and fall in front of the stairs or down the stairs, God forbid. It just doesn't make any other kind of sense. That's why the transit is responsible, and that's why they do it. Why would they pay people to do it?
Well, they volunteer, they say.
Well, it's a volunteer at a great expense to all us subway riders because they have to pay those salaries of all those cleaners. I mean, there's not just Ms. Stevens, there's many of them. So it just from a common sense perspective, it doesn't make sense to me, that argument. If there are any other questions, Your Honors, I'll be happy to answer them.
No, thank you very much.
All right, thank you.
And now, the attorney for HSBC, who's leasing from the Collin defendants, correct?
I'm sorry, was that?
You're leasing the premises?
Yeah, yes, I am, Your Honor.
Right.
And I just wanted to come up here to say that we believe our client cannot be brought back into this case at this point. We believe that because the orders that was appealed from did not implicate our client, that this court doesn't have jurisdiction to bring back our client in. And if the court has any questions about that, I'm happy to answer them. Otherwise, I rest on my brief.
You say because Collin did not appeal, we don't have jurisdiction to address
Correct.
the whole issue of responsibility?
Yes, the only notice of appeal has been withdrawn against my client, against that decision, and so there's no jurisdiction to bring it back in.
Okay.
Okay.
So, is there any questions?
Does anyone have any questions?
All right, thank you.
Okay, then we'll let Transit have 2 minutes to respond.
Yes, the plaintiff testified that on the previous Friday morning when she went to the subway, the area where she slipped and fell on Monday had absolutely no, had absolutely no snow and ice. All of the photographs in the record show that this is simply the sidewalk that goes up to the edge of the top of the stairway. I included in our opening brief a rather long URL to a photograph on the internet of a subway stairway that did have what I would call a landing, and which was apparently involved in that Echeverria case.
But it is an area which your station cleaner says she would clean frequently during the course of a snow situation. Is that correct?
She said she would clean 3 feet out. But the landing in this photograph shows it's just a big slab of concrete, and it's raised maybe 3 or 4 inches above the sidewalk. The purpose of that is to keep rainwater from going down the subway stairs. That's a landing. I would agree that that was incidental and necessary to the subway system, but when that's not there and it's just the sidewalk that comes up to the stairway, then the sidewalk is not part of the lease
And
premise.
how can it not be incidental? I mean, how else are you gonna get to the subway unless you like jump all the way down the stairs? I mean, how are you gonna get to it if you don't walk over that sidewalk?
Yes, you
The
have
one or
to
two-
walk over the sidewalk, and the administrative code says that the adjoining landowner is responsible for keeping snow and ice off it. It cannot be that when the city entered into the lease, that it intended to lease to transit some unspecified number of feet of sidewalk at the head of subway stairs. It's not even true in the
I
city.
know I asked you the question, but I just want to be sure that I caught your answer correctly. The area on that supplemental picture that you submitted today, which has an area drawn in, that's an area which Stevens indicates she would clean if there was snow. Am I
Yes.
correct?
Frankly, I'm submitting it because it was a photograph that should have been in my record, but I think it's irrelevant. She testified that she cleans up to 3 feet, and we feel that that's not assuming a duty.
But that would cover the area shown in the picture you submitted today.
Yes, there's the little X that the plaintiff made, which is clearly within 3 feet of the top of the stairway.
Okay. Okay, any further
Thank you.
questions? Okay, thank you all. The next case for argument is People versus Count C. Good afternoon.
Good afternoon, Your Honors. Harold Ferguson for Appellant Count C. We're simply asking this court to follow the lead of the Appellate Division Second Department, which has held that the repeal of the mandatory surcharges and fees as it relates to youthful offenders applies to this situation, and this court should adopt the same standard that the Second Department has done.
I mean, I know you've read that, and at least 5 or 6 occasions, we have chosen not to do that. I mean, I know you are aware of that.
Your Honor, you're talking about the situation when it was a discretionary thing, when it was a person who was 21 and under and wasn't adjudicated a youthful offender. That's the discretionary part of it. We're arguing that since this was a youthful offender, the repeal of the provision that allowed for the imposition of the mandatory surcharge and crime assistance fee no longer exists, and therefore it is not a discretionary act. If the statute applies retroactively, as we believe it should, since it is a ameliorative statute, remedial in nature, and looking what the legislature has done in the last couple of years as it relates to youthful offenders, that as the Appellate Division Second Department did in the second iteration of Daishawn B, that in this type of situation, it is not a discretionary act, that if the statute applies retroactively, it is mandatory that these fees and surcharges have to be vacated.
And do you take the position that the waivers in this case were not appropriate waivers, or that even if the waivers were, that we still are able to deal with this?
Absolutely, Your Honor, because the issue of the mandatory surcharges and fees only was raised at sentencing, and there was no way that you can prospectively waive something that hasn't come into existence. The repeal of the provisions of the penal law came afterwards. There's no way that the waiver could have encompassed that because it would have had no way to anticipate that the legislature was going to do anything. And so we believe that if this court follows the precedent of the Second Department and Daishawn B and Caron H, that what should happen here is they will apply it retroactively and to vacate the fees as it relates to to Count C. Thank you very much, Your Honors.
Thank you.
Good afternoon, Your Honors. As a threshold matter, this defendant validly waived his right to appeal, and regardless, the amendment to the law should only be applied prospectively. If your honors have no further questions, we rest on our papers.
But do we, well, do we need to rule on the retroactivity at all, or can we skip the issue?
Well, in this,
Particularly in light of the waiver.
well, yes, Your Honor. The waiver would just, because the defendant validly waived his right to appeal, there is no need to address the underlying claim of the retroactivity. That's true.
Any other questions?
I'm good.
Okay,
Thank you.
thank you. Mr. Ferguson, you have a minute if you'd like to add anything to your argument.
Just to return to Justice Acosta's question, I believe that the waiver, as I answered before, doesn't apply to this situation, and we ask this court to vacate the fees in this particular case. Thank you, Your Honors.
Okay, thank you both. The next case is Tudor Perini.
May it please the court, counsel Jim Barriere for appellant Tudor Perini. The lower court erred in dismissing this case under 3211. This is a very
What
unique.
is the effect, if these are regarded as damages for delay, what is the effect of that on your position?
Well, let's look at the contract definition of extra work, right? Which is work other than that required at the time of award. What's unique about this case is all of the work.
If it's damages for delay, are you under Article 27 or under Article 56?
What's unique about this case, Your Honor, is I think you could argue we were subject to both. Because there's no question the work, and even the city agrees, was all different from the work performed at the time of award. So we proceeded with the claim, and the city recognized Article 27 as the vehicle because they came back to us in response and said, if you disagree with our denial, go to Article 27.
But isn't another problem with this particular case that there was an Article 78 brought before this case, and it came up to our court, and we specifically found that your claims were not for extra work, as you urged, but rather for delay damages.
Yes, and
Aren't we
I'd like to.
controlled by what we said last year?
No, I accept the court's decision. I argued my point and did not prevail. But let me kind of walk you through.
Aren't you trying to appeal that?
May I walk you through exactly how that happened very quickly?
Yeah, and in that explanation, please address the issue of collateral estoppel.
Okay, yeah, I'd be happy to do that. All right, so we bring the claim for extra work payment.
Correct.
The city disagrees and says go to Article 27. We go to Article 27. In May of 2019, the comptroller says, we are converting your 4 extra work claims to 1 delay claim, right? We're already underway in the CDRB process, okay? So we go through the CDRB process and we get the CDRB decision in October of 2019. The 6-month statute of limitations has now expired under the first clause of Article 56. And the CDRB says, Tudor Perini has other available options and may seek relief from courts that have broader powers to fashion appropriate remedies. In other words, the CDRB says, look, we're not going to disturb the comptroller's decision that this is delay and not extra work. But you can go to court on your delay damage case. That, Your Honor, is why there's no collateral estoppel here, because the CDRB did not address what's at issue before the lower court right now, which is delay damages. They simply said you can go to court for that.
Yeah, but CDRB said that, I mean, in the Article 78, let's put it differently. In the Article 78, the question, what was the issue in the Article 78?
Whether or not this was extra work that was.
I mean, you argue. Wait, let me ask a question. So you argue unsuccessfully that your claim were for extra work because the construction work was different from the bid, right?
Yes, I did.
That is, in essence, the same exact question now. So how do you get two bites at the apple, both in a plenary action as well as in the Article 78, where we disagree with you?
Because
I know that it was a higher
it
lower or higher
it was
standard
a higher
in an
standard,
Article
but
78 proceeding.
respectfully, Judge, we're not arguing in this case that the work we're seeking to be paid for is extra work. We are accepting this court's decision. We're accepting the CDRB's decision. We're now saying, okay, fine. We will present this as a delay damage case. We had to follow, in our view, Article 27, not only because they told us to follow it, but because it was extra work. The CDRB just simply said, we're not going to recognize it as such. It's a delay case. So now, by the time we go through the contract process under Article 27 to get to that decision, our first 6 months is gone. So what event triggered the claim? Well, the event was the conversion of the claim to delay, which was after substantial completion, and under Article 56.2, the second 6 months applies.
But why is the event that triggered the challenge relevant at all? The question is whether you raised the same issue before that you now bringing before the court, an issue that we already addressed, namely the construction work difference from the bid itself.
Your Honor, I can't argue strenuously enough that our complaint before the lower court is for delay damages. And our complaint before the CDRB was based on extra work, which was rejected. And the city contract does not preclude us from proceeding in that fashion.
But then I go back to the question I asked before. I understand that was your position, and I understand that we didn't accept it, but didn't the fact that we specifically stated in the Article 78, where you did try to take leave to the Court of Appeals and it was denied recently, that we found that they were actually delay damages, doesn't that control the day here?
No, it doesn't, because again, I'm not collaterally estopped from arguing a delay damage case when I did not previously argue it in the other case, and when the CDRB expressly said you could go to court on that.
Yeah, but we found that they were delay damages, even though you didn't. I mean, I know that wasn't your position, but unfortunately, we did not agree with
Your Honor, this lawsuit that's pending below accepts the court's decision and says, fine. We were wrong. They are delay damages. Let's have the case on the delay damage clause. Let's have the case on the exceptions. That has not been litigated.
So, counsel, are you saying that you can contractually sidestep the collateral estoppel doctrine? That you can say if you contract with them for, an administrative challenge in an Article 78, and the contract also allows you to sue in a plenary action, that's okay, although this court will wind up deciding the same issue?
That's not okay, and that's not what we're doing. What collateral estoppel says I can't do is argue it's a delay case through the administrative process, lose, and then sue and say it's a delay case in court. I can't do that. I'm collaterally estopped. I argued it's extra work, not delay. Court disagreed, CDRB disagreed, and I brought a separate action saying, okay, it's delay. And we'll argue it on that basis. And nothing in the contract prevents me from doing
on February 12, 2019, February 12, 2019 is the date that the substantial completion certificate is issued. Is that correct?
That's correct.
So you have 6 months from that date, isn't it?
As of that date, my cause of action had not accrued for two reasons. One, the comptroller had not issued its decision, which you can't sue until the comptroller issues a decision.
Well, but didn't you know in March of 2019 that Article 27 didn't cover this action when the controller issued a determination that DOT correctly classified the plaintiff's claims as being for delay damages?
On March 18, 2019, we were told that these claims were being converted to a delay damage case, and we were further told
isn't that when you should have known that you were in danger of the 6-month period in Article 56, that you had 6 months from the date of substantial completion?
Respectfully, no, because in that determination that converted the claims, they said if you disagree, go under 4.09G of the PBB rules, which is the CDBR process that we had already commenced and started. And frankly, in our view, We have to exhaust that
Well,
contractual
for that, you need to
remedy.
rely
No,
on
but
estoppel, don't you?
I beg your
For
pardon?
that, you need to rely that they should be estopped.
Well, yes, absolutely, for two reasons. One, they told us in December to go under Article 27, and then the comptroller told us in March to go under Article 27. The lower court erred and said it's not available with respect to public agencies. Even the city concedes the point that it is available, and the facts and circumstances need to be extreme and unusual. I get it, but that's an issue of fact. That gets this case back before the lower court for an examination of the facts.
But why shouldn't you have thought that you were running into trouble with the 6-month period under Article 56?
Well, first of all, I think it would have been a waste of judicial resources to follow the contract process and at the same time bring a separate action in court. Secondly, the event giving rise, triggering the delay damage claim, occurred when it was converted after substantial completion, and under the second prong of 56.2, the second 6-month statute of limitations applies, and we're within it. I think the court just applied the wrong statute. And frankly, none of this is even addressed by the lower court. Not the fact that there was this contractual procedure, not the fact that we were told to follow it, not the fact that we followed it to the letter. None of it was even addressed by the court. It's as if we sat on our hands and did nothing to pursue the claim, which is not the case. And that's not how these clauses should be used.
Okay,
Thank
Justice
you.
Hagan, did you have a question? Or do,
No, it got flushed out. Thank you.
okay. Okay.
Thank you, Your Honor.
Thank you. You'll have 2 minutes for rebuttal.
Good afternoon. May it please the court. Lorenzo De Silvio on behalf of the city. So Tudor Perini's central claim is, well, we couldn't have known that these claims weren't for extra work, and the city told us to go the Article 27 route. But I'd like to walk the panel through why the premises of those arguments are just not borne out by this record. First of all, we marshaled the record evidence from the Article 78 proceeding, to which Tudor Perini does not respond, dispute, or distinguish, that showed the minute they asked DOT for more money, they were referring to excusable delay and referring to the acceleration efforts they undertook. And under well-established case law predating the dispute in this case, those are delay damages. And under well-established case law, which again, yes, Your Honor.
And the DOT commissioner, excuse me, with respect to plaintiffs' compensation requests, told plaintiffs specifically that this was going to be, and this was in denying the compensation request, told the plaintiff this was the final decision by the commissioner.
Yes, Your Honor, and that was before the limitations period in Article 56 had expired. But Tudor Perini is also incorrect to the extent that they suggest that it was DOT who came up with the idea to go the Article 27 route, because Tudor Perini admits in its complaint, and in the record materials from the Article 78 where it asked DOT for more money, it said—
Did you send them a letter and tell them to go the Article 27 route?
Well, we need to start before that, Your Honor, because when they asked for more money from DOT, they invoked Article 25 of the contract. Article 25 of the contract says you can get more money if you did extra work. So when DOT says no in December 2018, 2 months before the certificate of substantial completion was issued, it said if you disagree, you can go Article 27 and go all the way up to CDRB in Article 78. But that's because the only way you can challenge or adjudicate something that they've already said is extra work is under Article 27. But leaving all that aside, DOT told them before substantial completion certificate was issued, nope, these aren't extra work claims. The commissioner did so 2 months before the 6-month limitations period expired. The comptroller 3 months before. But even if, as Tudor Perini insists, it really couldn't have been sure that these weren't claims for extra work, why couldn't they have just transposed their CDRB petition, which contains all of the essential allegations necessary for their claim now, which is on page 270 of the record in this case, and was drafted in April 2019, why couldn't they have just transposed that into a complaint and within the next 4 months filed it in court? It's not a waste of judicial resources to do, you know what, we want to be defensive, we're really not sure about this, we want to protect our rights under this, we're just going to file this and then ask for, say, a stay because there's this Article 78 proceeding going on which could moot it out. That's the situation that Tudor Perini finds itself in, but it's just not this court's job or the city's job to save it from its own mistaken decision to put all of its eggs in the Article 27 basket. And on the point about this idea that they didn't have 6 months from the certificate of substantial completion, there's just no serious dispute here that they're seeking money for work that they performed before substantial completion. They made the request to get that money before substantial completion. They were told no before substantial completion. So this idea that it was something they had to wait until the comptroller or the CDRB, that's just wrong. And what the CDBR was saying regarding you can go to court, they don't have jurisdiction under Article 27 to address something that isn't an extra work claim. So they weren't saying you can go to court and if the city, moves on a limitations defense, they're stopped. That's just not the case here. This wasn't like Conquest Cleaning, one of the cases they cite in their brief, where a contractor was repeatedly told, just give us the documents, have a couple meetings, we're gonna pay your request, but was never told, we're not gonna pay your request. Tutor Perini seems to insist that we should have told them, hey, we're denying your Article 27 claims. By the way, there are these other provisions of the contract that you could sue us under. You should be mindful of those things. That's just not our job. This court should affirm because the contract claim is untimely and Tutor Perini doesn't dispute that a valid and enforceable contract governs the subject matter. So the unjust enrichment claim is out too. And there's no fact issues that need to be resolved given that Tutor Perini knew everything it needed to make its estoppel argument here. So this court should affirm.
Okay, thank you.
Thank you.
So let's think through the city's responsive argument. I bring a claim for extra work. They tell me to pursue Article 27. I pursue it. It's converted in March to a delay claim. And the city says, you should have sued us in court on the delay damages and simultaneously pursued the claim as extra work in the CDRB.
But they sent you a letter to that effect, actually. They did.
So the city goes into court and says, hold on a minute. We told them to go into Article 27. They're going under Article 27. That's the sole remedy here. They're out. Can't argue delay if you've brought it under Article 27 pursuant to our instruction. And then the city goes to the CDRB and says, hey, they sued it for delay damages. It's not extra work. They've conceded that. They're judicially stopped. So they have a contract process that we have to follow.
That's not a novel proposition. I mean, the city they're your opponent. They should not be guarding your timeline limitations.
Your Honor, that's not the city's role to guard our timeline limitations. But it's also not the city's role to create a contract document that gives my client a Faustian choice. We submitted it. They said, follow this process. We followed the process to conclusion. By the time it concluded at the CDRB, the 6 months had run. We were in the second period, and we brought our relief. But to say you should have sued two different claims simultaneously, Your Honor, I just don't think that's a genuine position for them to take because we can't do that and prevail in either venue.
Yeah.
Unless the court has any further questions, I will sit down.
Okay.
Thank you so much.
Thank you both. The next case for argument is People versus Ahmed.
Good afternoon again, Your Honors. Harold Ferguson for Appellant Omar Ahmed. This case should
Double duty, Mr. Ferguson.
What was that?
Double duty.
Hey, I'm quite happy. I'm here tomorrow, too. You could have made it really easy and done all three, but 2 out of 3 is good. This case should be controlled by this court's decision in People versus Lugo. In Lugo, this court held that when you remand for a youthful offender determination, it is up to the resentencing court that is to address the mandatory surcharge and fee issues, and that's what we asked this court to do in this case.
So if we remand for a YO determination, we don't even need to address or reach the issue of fee or surcharge, right?
That is absolutely correct, Your Honor. In fact, your precedent in Lugo says it is the responsibility of the resentencing court. Thank you, Your Honors. Have a great day.
Thank you. Well, after a couple of years of not coming to visit us, at least, you get a couple days. So. Not terrible. Yes, counsel. You're doing double duty also.
Yes, Your Honor. And if Your Honors have no further questions, the people rest on their papers.
No, you agree we should remand for a YO determination, right?
Yes, that's correct, Your Honor.
All right. So let's not reach anything else.
That's correct.
All right, well, Nice of you to visit us. Have a great afternoon.
Tomorrow.
Okay, well, you'll see other judges tomorrow afternoon. Okay, and last, we have the ALP and Adam Max cases.
Good morning, Your Honor. Good afternoon. Apologies, Your Honors.
Good
Karen
afternoon.
Klein, on behalf of appellant Adam Max, who is appealing from these two decisions in these related actions.
Right.
With respect to the ALP versus Moskowitz action, the trial court should have dismissed respondent's amended complaint and supplemental summons because respondents never filed a motion for leave to add new parties or to amend their complaint.
So how long was he in this case during the time that there had never been a formal proceeding to allow him into this case?
So this case was brought in 2019. There were new parties added a couple months later.
Right.
And then in May of 2020, respondents filed a proposed order to show cause for a preliminary injunction. And one of the provisions of that proposed order said, we can provide service of the supporting papers, including this amended complaint, which purported to add parties and amend the complaint on appellant and a non-party, not on the other parties to the action.
Regardless of the action in which he's named as a defendant, and the action which he commenced, based upon the counterclaims, he's been pushed out. He's no longer a director. He's not permitted to seek to call a meeting, which he wanted to call, to put himself back in charge. He's got no role in ALP at this point.
That's correct, and that's one of the other bases on which we appeal, Your Honor. The preliminary injunction was issued under BCL 706 and 716. Under BCL 706 and 716, the court may only remove someone as an officer or director who is a current officer or director and then bar them.
What establishes that he wasn't a director? He stops coming to meetings, but at the pertinent times, he was still a director. He just decided not to show up.
No, we disagree with that, Your Honor. At the board meeting in August of 2019, several months before the preliminary injunction motion was brought, the statement was made that he would have no role in ALP whatsoever. That was made by Libra Max, one of the respondents. After that point, he stopped receiving any notices of board meetings. In the several months before that, he got about 10 notices of board meetings. In the several months after that, he got none.
But anyhow, there's a lot of history to this case, and it's been back to this court many times. Based upon what's transpired until now, where is there a place that there's anything that we can do for you? Because what you would really need to have happen here is have a receiver appointed or force Libra and Adam to come to each be named directors and be forced to agree on a third director. But those possibilities of relief are not really open to us in the litigation as it now stands in front of us.
Well, what we were seeking, Your Honor, below was to call a shareholder meeting in which the majority of the shareholders, Adam and the guardian for his father, Peter Max, were going to vote on the board, the members of the board. Respondents filed a preliminary injunction to enjoin that meeting and to stop Adam from being a candidate for the board and an officer. That's where we think the court erred below. In order to establish that relief, even if Adam was an officer or director at the time of the motion, which we think he was not, they did not establish that they were likely to succeed on their claims. Now, the court below, the evidence before the court below that was submitted by respondents was largely affidavit testimony of Libra Max. Adam Max put an affidavit saying, no, that's not true.
Well, how do you justify Adam enters into an agreement with with Flynn in which he's going to agree to transfer the paintings back to Flynn. How could that possibly be for the benefit of ALP?
So that agreement was in contemplation of settling claims that Flynn had affirmatively brought, in which Flynn claimed that Peter was the sole owner of 100% of the artwork that he created, and that Alp created none of it. So that agreement was not one in which Adam was giving away the property. It was one in which Adam was contemplating a settlement of existing claims.
It was one in which he was contemplating a settlement of an existing claim in which he's going to give Flynn everything he wants so that he can become a director of the corporation.
No, Your Honor. Flynn wanted 100% of the artwork. That's not what Adam was agreeing to. Adam was agreeing to effectively split the baby so that the corporation kept a substantial amount of artwork, and Peter also had artwork for which the corporation would act as the sales agent. And I'll also note, Your Honors, that that agreement was subject to court approval. So there was no side agreement that this was going to come into effect. That agreement required court approval, and if respondents were correct that it was somehow voidable or a breach of their duties, they could have presented that argument to the court when they sought it to be approved. And I'll just note with respect to the conflicting evidence below, the affidavit testimony, the law is clear that where the facts are put in affidavits and they're disputed and contradicted, the court is required to hold an evidentiary hearing and can't rule simply on those competing affidavits. The court never held that. With respect to harm, if I may just finish very briefly.
Yeah, sure.
With respect to irreparable harm, the only harm that the court below held that existed was the enforcement of the potential settlement agreement. Again, Your Honors, if that was, we don't believe that there was any harm that flowed through that, but if there was, the right remedy would have been to narrowly tailor the relief to enjoin that agreement or the offending portions of that agreement, not to bar Adam from serving as an officer or director entirely. And again, the equities, I'll direct the court to our papers, the equities clearly favor Adam here. What Libra is doing is effectively trying to bar a shareholders meeting, acting on behalf of the company as a minority shareholder, while cutting distributions to her father by 80% to a point where he can't maintain his basic needs anymore, cutting Adam's compensation entirely, refusing to call any shareholder meetings, annual meetings or the like, and refusing to provide any disclosures to the shareholders.
Okay.
Thank you.
You'll have 2 minutes in rebuttal. Thank you.
Good afternoon, Your Honors. I'm Jeffrey Islander from Schlomstone and Dolan for respondents Libra, Max, and Alp.
So as things stand now, how is Adam's interest protected here? Libra's basically been put in total charge.
Well, Adam is still a shareholder, Your Honor, and his interests are protected under the BCL. I mean, what the problem is that he entered into an unlawful
Basically, the
agreement.
idea here is that Adam had 40%, Libra had 40%,
Yes.
and 20% remained with Peter. But that was if they're both on the board of directors, which probably was the contemplation. But now Libra, as a 40% shareholder, controls all the positions on the board.
No, she doesn't. She controls it until the next election. The reason why there hasn't been an election is that there's a question as to how Flynn can vote his shares. Okay, Flynn admitted that Adam breached his fiduciary duty, and to put Adam back in would be a violation of Flynn's own duties. Flynn decided to enter into an agreement in which Justice Bannon found was likely to be shown illegal. Okay, you know, they've now tried since then, and I don't know if Your Honors can take judicial notice of this, they've now tried the same thing, and Justice Bannon issued another TRO, which they've decided not to appeal.
I don't know with the way Flynn has taken diametrically opposite positions on this, how you can rely on anything that Flynn would propose here in terms of being consistent with fiduciary duty, et cetera. You know, sort of.
I mean, Your Honor, the problem here is, you know, they entered into an agreement which, as you said just a couple of moments ago, was essentially a bribe. Okay, Flynn was going to vote to restore Adam to control of the company. There was no disputed record on this. The court had found, based on all the prior proceedings, that Adam
Supreme Court's decision as it now stands prevents Adam from coming back onto the board,
correct.
for now, right?
During the pendency of the action. It's not a permanent order, it's just a preliminary order, but yes.
Preliminarily, that's
Yes.
the effect of the order, that he cannot be on the board.
Yes.
So, but what's needed here is some disinterested third party to see that this corporation is operated for the benefit of the two shareholders who are meant to be its beneficiaries. And the way things now stand, it seems like there is only protection for Libra here.
Well, Your Honor, they have their remedies. If they believe that there should be a receiver, they can make a motion for receiver. They haven't done that.
There was a prior request for that relief.
Yes, and that was dismissed by, the claim was dismissed by Justice Bannon, and I believe it was affirmed by this court.
Yes.
I mean, look, part of the reason why we're in this conundrum is how it's been advanced by Adam. Okay, if Adam wants to go back and make a motion for a receiver, Justice Bannon will consider it and we'll deal with it. From our perspective, the reason why there's a problem, sorry, I can't.
So how's there ever going to be another shareholders meeting? There hasn't been one in years now, correct?
I think the problem is we first have to determine who can vote, okay? And there's a question as to whether Flynn can vote, given the way he's trying to do this deal with Adam.
So does there have to be a hearing to make that determination?
Okay, so what's happened since then is we've made a motion to Justice Bannon asking her to determine whether Flynn can vote. And if he can't vote, asking her to appoint someone else who can vote Peter Max's shares.
Who was it, Justice Bannon, that appointed Mr. Flynn to be the guardian for Peter Max, or was that someone else?
Mr. Flynn was appointed by the guardianship judge. I think at the time it was Justice Vistacion Lewis.
Okay.
And we have a similar, look, Your Honors, I mean, this is part of a larger
I know, I've been on this case.
I think you've been on every panel.
Yes, I have.
Just to give you the trailer for the next appeal you're going to deal with, we have a petition in front of the guardianship judge to remove Mr. Flynn because we believe he did breach his fiduciary duties. We've asked the guardianship judge to determine whether Mr. Flynn can vote. We've asked Justice Bannon to determine that. We have been told by the guardianship judge, who is now Justice Salovey, that she is in touch with Justice Bannon, and they're trying to come up with an organic solution for all of this.
Shouldn't Supreme Court have held a fact-finding hearing before it issued this injunction?
No, because there was nothing in dispute. There was no dispute that the agreement was in essence a bribe to Flynn. Both of them admitted it. Justice Bannon looked at the agreement itself. There was no dispute that...
Counsel here is disputing it today, that's what it meant.
Well, Your Honor, there was no dispute that a commission was paid to Lawrence Moskowitz of almost $5 million against the resolution of the board.
Yeah, but there's an explanation. He produced all of those millions of dollars in insurance money for the damage done by the hurricane.
He wasn't as a matter of law, he wasn't entitled to get a commission. He didn't have a license.
He didn't, I remember that from another.
Right, yeah, there you go. We could write a book. He didn't have a license, Your Honor. I mean,
one of the counsel. You gave us, you were attempting to give us a trailer for the next appeal. Is one of the issues, is there a pending request for the appointment of a receiver?
Right now, there isn't. There was, and it was dismissed.
Yeah. I mean, it sounds like all the money for the estate is going to go to you folks.
I wish.
At this pace.
You say that there wasn't an entitlement to the commission because the person isn't licensed, but does that mean that it's illegal to have paid that person a commission if that person succeeds in producing over $40 million in insurance?
I mean, first of all, the short answer is yes. Second of all, he didn't just steal $4.8 million. He actually stole almost $7 million, Your Honor. He caused Alp to put $2 million in escrow for himself for absolutely no reason. Plus, he got almost $5 million when the board said he shouldn't have gotten it, okay? And Adam did it in secret. None of this was disputed. It would be one thing for Adam to go to the board and say, you know what, I think you're wrong. The guy's entitled to the money. That's not what happened. The reason why we have a Park West case is what Adam did is he sold about $400 million worth of art at a steep discount, so he get $15 million in cash, and of the $15 million in cash, he took $5 million of that and he secretly gave it to Moskowitz behind the back of the board, and when he was no longer the CEO. He consummated the deal when he had already been removed as CEO.
Okay.
I mean, none of that is disputed.
I'm not sure any of that is exactly what's here today, but it sounds familiar. Okay,
sure it
do
does.
any of my colleagues have any further questions? All right, well, here,
Just waiting for the appointment of our receiver.
somebody's got to move for it, I guess.
We'll be back next summer on that one.
Yeah.
Okay, we look forward to it.
Thank you, Your Honor. Just briefly, just want to address a few points that were raised. Mr. Islander said nothing's in dispute. I think it's pretty clear that we're disputing all of this.
Well, how do you justify all those payments that counsel has alluded to?
So we've explained, as Adam detailed very clearly in his affidavits, that there were reasons for these payments. These payments were made based on work that was done by these other parties, and these payments were agreed to in advance of the one board resolution that Justice Bannon used as her hook as what was being violated here. So there was a board resolution that was entered into in December of 2018 saying we're not going to make saying that no payments can be made over a certain amount without board approval. The payments were all agreed to prior to that. And Adams put in his affidavit that everything was agreed to prior to that.
But even
and the bottom line is, if there's
But who agreed to those payments? Is it just Adam and the insurance adjuster, or was there some corporate formality observed in agreeing to those payments?
it was ALP who agreed, and Adam at the time was the president of ALP. But the bottom line is there was a dispute about the rationale behind those payments, and the court should have held at a minimum an evidentiary hearing to determine whether the explanations being given were credible and were valid. Instead, what she did was she took the testimony or the affidavit statements of Libra Max and credited them while completely not considering and discounting the statements of Adam Max. And if I could just give one example, because I think it's illustrative. So for example, the court held that one of the bases for granting relief was that respondents were likely to succeed on their claim that appellant breached his duties by causing ALP's insurance coverage to lapse. There was one statement in Libra's affidavit where she said, when I became president, I found out that the insurance lapsed. Adam put in an affidavit in response that said, that's not true. I diligently sought insurance and I was rejected by multiple insurance providers. I was told that the warehouse was uninsurable because of the magnitude of prior losses. And by the way, Libra has not been able to obtain insurance either since she took over. Now, the court credited Libra's testimony and completely discounted what Adam said, and that's contrary to the law. Where there's an issue of credibility, where there's an issue of two competing stories, the court has to hold an evidentiary hearing, and it just didn't here. And just one note with respect to...
Okay, one more.
Sorry, this is my last comment, I promise.
Okay, thank you.
With respect to the comment that about Flynn, there's a dispute about whether Flynn can vote Peter Max's shares. That's just not accurate. The guardianship court held that Flynn is able to vote Peter Max's shares. Respondents have taken the position that he shouldn't be able to in the future because he somehow breached his duties when he entered into this agreement. But the guardianship court already held that he is able to vote his shares, and they're just seeking his removal. So that's the issue. And Flynn has explained that his prior statements about appellant here, about Adam Max, were because he was misled by Libra Max.
Okay, well, thank you very much. Perhaps we'll see you again, and have a nice afternoon.
I'll stay here if you want. I think you're right, Lieutenant Gill. It's common courtesy, Lieutenant Gill.